All right, if the Swarmer was about a lot of flurries, a lot of energy, and the Brawler was about one punch knockout on one or two issues, this attorney style we're dealing with this episode is the Boxer, and they're about power punching. They're about building a case. They're counter punchers. And it's the first style that's defensive because the Swarmer and the Brawler is an offensive style. A boxer's generally up against cases that are difficult, not against other boxers, but against Swarmers or Brawlers. So what usually happens is there's an issue with negotiating support, either child support or spousal support. And in many states, like New York, where I practice, there's a formula. But in a lot of cases, when you make more money, there's a lot of discretion over a cap. And the cap is, moderate. But if you make a lot of money, or you feel like you make a lot of money, the court has a lot of discretion. And they base it basically on lifestyle. I mean, maybe other factors, but that's usually, lifestyle, status quo. That's what they usually deal with. But sometimes you could take the position that why don't you just apply the child support or maintenance formula to all the income, independent of the lifestyle. And that's what the position was of this Swarmer. We weren't getting anywhere because this individual did make a lot of money, but it didn't go to lifestyle. They used their money to build investments, wealth, not spending. Didn't even have a car. The rent on the apartment was moderate, very moderate for their income. Just not flashy. So things break down settlement. They made an application, a motion to the court. That involves writing papers. That involves a lot of time. It involves going to court. Then you have to do opposition papers. You have to oppose their papers. Then you have to go to court and have oral argument. Clients have to go. The attorneys can go. So you can see how this can run up the bill. And if you're on an hourly model, that could be tens of thousands of dollars. They also asked for, obviously, because they were the non-moneyed spouse, attorney fees. Because in a lot of states, the moneyed spouse have to pay in part the non-money spouse's fees. So there's no disincentive to run up the bill, right? If you represent the non-moneyed spouse, in part. I say in part because maybe you're not going to get all the money back if you represent the non-moneyed spouse, if you take unreasonable positions. And they made their arguments in court. I knew who this judge was and, made the arguments that, there's a lot of money here, a lot of income, but didn't go to lifestyle and look at the statute. Roll up my sleeves. This is how it's done. And the court saw that. But I had to also use the counterpunch. Maybe that was a defensive block because they come at me. That was the block. Like, boom, you're not going to get through me. But then I had to punch back. That's what good boxers do. And in this example, there was a property dispute, not really anything central to the motion, but I knew it would just show how unreasonable the other side was. And I ended that conference with that issue, dealing with personal property. And the judge saw how unreasonable the position was, how unreasonable the other person was. And when they came back with the order on the support, it was about, 2 or 3% off of what I suggested. Okay. And if they just accepted that, we would have saved all that time, money, and energy. That's dealing with the boxer. So how do you identify what a boxer's all about? Well, the boxer, as I said, is defensive style. They don't really want to hit you. They rather you resolve your case cooperatively, even collaboratively. The difference between cooperative and collaborative or divorce attorneys don't go to court. They do everything outside. So you have mediation. That's just two spouses, and then the mediator facilitates. But if you need more support, you can do collaborative. But if you feel like someone's being unreasonable, you have to then go to court. That's a cooperative attorney. The only problem is you might mistake, especially more experienced boxers, their cooperative nature for a lack of ability to really frame the case in their client's way. You might think you can just push them around. But good boxers are going to come back and counterpunch, not be just defending, not just blocking. Now, what would a boxer not want you to know about them? How do you beat a boxer, basically? Here's the thing with being a boxer. A lot of the value is in the attorney-client relationship. And the client is a partnership in that relationship, right? But unlike the swarmer and unlike the brawler, a lot of that is attorney-led. And here, I think the boxer is much more cooperative. So if you're able to really, I guess, destabilize the client, then that partnership may be weakened. And that may be a way to get through to the boxer. All right, so let's put our lawyer hat on for a moment and just bring this home. If a swarmer is about chaos and the brawler is about being like a blunt weapon, the boxer is really about building a record. And I want you to understand, these high conflict divorces, it's not like in tennis, if you know tennis, these matches, these Grand Slam 5-set matches, two of the best players in the world, it's not 6-0, 6-0, 6-0. It's tight. They're playing for 5 hours, killing each other. And if you just tally up the points, it's usually very, very close. That's what I want you to realize, what you're getting into in these high conflict divorces. That's what I'm talking about. It's not like a landslide. If it's a landslide, then you settle early. The core message is the boxer doesn't need to beat you. You're sort of beating yourself by taking unreasonable positions, being in fantasy. So here's my action step for you. Just ask your attorney, what would the judge likely do? Now, sometimes you can take a position where you might, if the attorney says it's 15%, that's a value judgment. If you want to go up against something with the judge and try to make new law, or you feel so strongly about something and it's only 15% and you have the budget, fine. But in most cases, just think of it like a job listing. If the job listing says salary $100,000 approximate or estimated around, and you make a 125 offer, if they like you, they may accept that. But they're not going to accept 300,000. That's ridiculous. That's unreasonable. That's in fantasy world, and that's what you're dealing with. All right, so I'm Corey Shapiro. This is the Getting Divorced Without Losing Your Mind podcast. Let's step forward with clarity together.
This podcast offers general information only. It cannot replace legal advice. If you need tailored advice, contact an attorney licensed to practice in your area.